Tayyab, am I audible to you?
Yes.
Yes.
Okay, so I'm there. I don't know whether my name is reflecting there. Tayyab, can you just cross-check? I just
No,
joined the
not your
meeting.
name is not reflecting. Only Samsung is visible.
Okay. I will just look into it. But I'm there, okay? Tayyab and Junaid.
Okay.
Okay, sir. Okay, sir.
Okay.
And for the moment we have all been waiting for. Good evening to everyone, and a very warm welcome to the final of the first Lexicon Arbitration Moot Court competition. We have reached the end of the journey that has been anything but ordinary. The previous rounds were marked by sharp arguments and strategies and a level of rigor that have pushed every team to bring out their best. It's been a pleasure watching the competition grow stronger with every round. We are deeply honored to have with us an esteemed panel of arbitrators for this round. Our first arbitrator is Ms. Seema Parthsarthi. She is a seasoned legal practitioner with over 24 years of experience. She has been actively practicing before the High Court of Kerala as well as various subordinate courts and tribunals. She is a certified mediator with IICA, an accredited mediator with IIAM, and also certified with APCAM. She currently serves as an impaneled arbitrator with IIAM and an impaneled mediator with IIMA, MCC, and SMA. She also represents insurance companies as an impaneled advocate. We are truly honored to have her with us today. Joining her is Ms. Mohammad Hamad Siddiqui, an assistant professor at the School of Law, Graphic Era University, Dehradun. He completed his BA LLB from AMU and his LLM from CUSAT. Before joining Graphic Era, he taught at Yale University. His academic interests span constitutional law, human rights, public international law, and he has presented and published his work at several national and international platforms. Our next arbitrator is Ms. Sonam Datta Mehta, the proprietor of Sonam Datta Mehta and Attorneys. She is a APCM accredited mediator and an arbitrator, and is also certified and impaneled with IIM and CAIAC. Serves as a commercial arbitrator as well. She teaches as guest faculty at USLSS Guru Gobind Singh Indraprasth University and has previously worked as an assistant public prosecutor with the Delhi Secretariat. Her practice spans matrimonial, criminal, trademark, and service matters, and she regularly trains India's paramilitary forces on women and family law. We are very pleased to have her with us today. Now, the two finalist teams, LMC1 and LMC24, stand here battling to be the best team standing. All the best to both the teams. May the best team win. Before we begin, I now invite our bailiff to briefly explain the rules of the round.
Thank you, Akshat. For today's round, LMC01 will be representing the claimant and LMC24 will be representing the respondent. Moving ahead, I will now briefly outline the rules that shall govern the conduct of this round. Each team is allotted 45 minutes exclusively for the main oral submission, followed by the 4 minutes for rebuttals and sub-rebuttals, if allowed by the bench. Participants must keep their cameras turned on throughout the proceedings. To ensure a smooth and disruption-free session, all the microphones must remain muted unless a speaker is directly addressing the tribunal. In case of any connectivity or technical disruption, participants are required to rejoin immediately, and the tribunal retains full discretion to decide whether any compensatory time may be granted. Now, with the permission of the arbitrators, the tribunal is in session. All the very best to the teams.
Can the compendium please be shared before I start my speech? May it please the tribunal. I appear as the counsel for claimant Messrs. Lantern Business Consultants, honorable arbiters. This dispute is fundamentally about upholding the sanctity of contract and the commercial realities of the parties' joint venture. The respondent, Messrs. Peacock Movie Productions Limited, seek to evade their clear contractual obligations they benefited from by clinging to technicalities that are decisively rejected by established arbitration law. As the first speaker, taking 25 minutes, I shall establish the tribunal's jurisdiction and competence by demonstrating that Issue 1, a valid and binding arbitration agreement exists between the parties under Exhibit B1 and Exhibit B2. Confirm Issue 2, that the Singapore International Arbitration Center has jurisdiction to adjudicate the present dispute. And finally, establish Issue 3, the disputes arising from the co-production agreement are arbitrable under the applicable laws. Before I start with the arguments, would the Honorable Tribunal like to know more about the material facts of the case?
Yes, you can just give a brief facts about the case.
Much obliged. The present disputes arises out of a commercial agreement between the claimant, Messrs. Lantern, and they are incorporated in Kuala Lumpur in Malaysia, and the respondent, Messrs. Peacock Movie Production, a Mumbai-based film company. On July 3rd, the respondent came to the claimant seeking financial assistance of an already begun movie, which was later named as 24 Hours. After repeated representation, the respondent asked for $2 million for a period of 10 months that they promised that they shall receive on or before 6th December 2019. Later, relying on these representation that they had secured satellite rights from Sky TV, the co-production agreement dated 10th February was agreed upon, which meant that the claimant would give a no objections certificate to the respondent, but the consideration for the claimant was a 30% profit share on every profit of 24 hours movie. And it also contained a valid arbitration clause naming SIAC rules with Malaysia as the venue and Malaysian law as the governing law. On November 29th, the respondent said that there were some unforeseeable delays and hence led to the supplementary clause. However, when the film was released on 7th February 2020, the claimants were not told about the release of the film. Moreover, the claimants were kept in the dark about the film becoming a huge hit in India. The claimants only got to know about this from social media networking sites. The claimants sent a formal notice upon knowing this information. No response or payment was given by the respondents. Consequently, arbitration clause was invoked by the claimant on May 25, seeking a repayment of the initial principal amount of $2 million at 5% interest per annum and a 30% profit share on all the profits. And hence, we've estimated the total to be $10 million US. If the Honorable Tribunal is satisfied with the factual narration and no further clarification is required, may I now proceed with the issues?
Please proceed.
Much obliged. Issue 1 was that there was a valid and binding arbitration agreement. Honorable Tribunal, the existence of a valid arbitration agreement cannot be in doubt. It is submitted that the foundation of the arbitral relationship between the claimant and the respondent is firmly rooted in Clause 20 of the original co-production agreement, Exhibit P1, and Clause 16 of the amended co-production agreement, Exhibit P2, given on page number 14 and 15 of the proposition. These provisions collectively form the very heart of the party's intention to resolve any further disputes through the arbitration rather than the courts of ordinary law. Firstly, the respondent does not dispute the validity of the arbitration clause in Exhibit P1. The primary challenge rests on the fact that the supplementary agreement, P2, was unsigned. However, the law is clear. The intention to arbitrate governs. Starting with Exhibit P1, the Council would like to refer to page number 13 of the proposition, paragraph 1.15. The co-production agreement dated 10 February 2019 contains a clear, express, and written arbitration clause in Clause 20, stipulating that, and I quote from the proposition, any dispute, controversy, or claim arising out of or in connection with this agreement shall be referred to and finally resolved by the arbitration administered by Singapore International Arbitration Center. By employing the phrase any dispute, difference, or controversy arising out or in connection with this agreement, the clause casts a wide net, ensuring that every conceivable disagreement related to the agreement, whether concerning its performance, breach, validity, or even the existence, is to be resolved through arbitration. The inclusion of the dispute regarding existence and validity demonstrates that the party deliberately intended to entrust all questions, including challenges to the contract itself, to the arbitration process. From a legal perspective, the clause satisfied every requirement of a valid arbitration agreement in both the countries of the parties, which is Arbitration and Conciliation Act of 1966 in India, Singapore International Arbitration Act of 1994, and the UN Central Model Law of International Conciliation, Commercial Arbitration, all of which share the similar standards. The agreements in question are formal written instruments signed by both parties, which is Exhibit P1. The consent to arbitrate is explicit in the language of the clause, and the legal relationship is clearly defined. Mutual intent of the parties to arbitrate is further evidenced by their conduct. The claimant invoked the arbitration clause by issuing a notice of arbitration on 25th May 2020. And the respondent, by themselves participating in this arbitration under SIAC rules, thereby acknowledge the existence of the arbitration clause, as held in Dala Real Estate and Tourism Holding Company versus Ministry of Religious Affairs, given on page number 19, paragraph number 3 of the written submission, or page number 2 of our compendium. The participation of a party in an arbitration proceeding without objection constitutes a strong evidence of its acceptance of the arbitration clause's binding nature. Further, the amended co-production agreement, Exhibit P2, which was executed to modify repayment timelines, expressly carries forward the same arbitration mechanism. Clause 16 of P2, which is given on page number 15 of the Moot proposition, provides that the disputes shall be referred to the arbitration under SIAC rules and governed by the arbitration law of the judicial seat. This repetition of the arbitral language from the original agreement is not accidental. It shows the parties' consistent and continuing intention to resolve all disputes before SIAC. The
Yes,
respondents.
just a minute. Uh, so whether the unsigned documents can be treated as an applicability to this agreement?
Yes, sir, arbiter, it can be, because according, if we look into the Malaysian IT law, it says that when two parties are in a contract, but their main source or main way of communication was emails, or they were using electronic means of communication without having a signed document, it will still be enforceable. That is under Malaysian law itself, which governs the contract. Moreover, in Sulmerica, SIA National versus ENSA, this common law case, which is given on page number 26 of our written submission, it says that if there are two laws, which says that unsigned documents can be binding if both the parties have acted upon it. Does that answer your question?
What is the applicability of the unsigned documents in India, and what are the provisions regarding that in
So the
India?
main case, Sir Arbitrator, I can think of is Glencoe, the recent Supreme Court Glencoe case, which applying the principle of estoppel. In this case, even if the our argument is, even if the document was unsigned, number one, signing of the document is not the main contention here, because the document was only for record basis for archival reasons. It does not show that there was no consensus at Edom. Number two, if we take this landmark judgment from the Supreme Court, the Glencoe case, it says that if two parties have acted upon a mutual agreement, there has already the claimant has already done their part of the agreement. It binds the parties and has to be followed. Does that answer the question, Sir Arbitrator?
Give me the necessary provisions as well as the legislation which has been governed in India regarding the electronic signatures.
For electronic signatures in India, the main case that I can think of is number 7.
I'm not
Section
asking about the case laws. I'm asking about the legislations, and I'm asking regarding the provisions. Please be specific.
Yes, sir. So in India, we can look into Arbitration and Conciliation Act, Section 7, Subclause 4. It says that an arbitration agreement, if it is in writing, like in our case, it is in writing but not signed, an exchange of letters or even telegrams or other means of telecommunication, they will provide a record of agreement and will bind the parties together. So this legislation in India can be can be taken in our case.
Any other legislations?
Other legislation that I can think of is the Indian Contract Act, which says that Indian Contract Act, which says that principle of estoppel is applied in Indian Contract Act, and the Indian Evidence Act is also there, which says that admission of electronic evidence of electronic records as evidence. So which says that electronic means, as in emails, are viable. Moreover, the Information Technology Act of 2000 grants legal recognition. Now the BNS of 2023 also grants legal recognition to telephonic emails and SMSs and have the same weightage as a signed document. Does that answer?
Any specific provision defining the electronic signatures from any legislations?
BNS has a new section added this year in 2023 that recognizes electronic or digital media as evidence, which is section, and then we have section 65 of the IT Act, which also defines electronic evidence.
Okay, please go on.
Thank you, Sir Arbitrator. Coming to another case is the absence of physical, one of the key cases in this, which is on page number 21, paragraph 9 of our written submission, is Narbiram Power and Steel Private Limited, which says that when the parties' consent is there and they work according to the terms of the contract, you cannot say that a document is unsigned and does not bind them. Further, clause 16 of Exhibit P2 reproduces verbatim an arbitration clause of Exhibit P1. This shows that the parties contemplated the ongoing applicability of the arbitration structure between the agreements. A well-settled principle in arbitral jurisprudence is where multiple related contracts form a single electronic transition, arbitration clauses are to be constructed harmoniously. This was held in Chloro Controls India Private Limited versus Swern Water Trend Purification, also given in our written submission. The arbitration agreement, even if P2 does not survive and it is held null and void, the main contract, even if the main contract is alleged to be voidable or underperformed, it was reaffirmed in Fiona Trust and Holdings Corporation, given in page number 23 of our written submission, and also in our compendium. Lord Hoffman observed that parties are presumed to intend all disputes arising from the relationship to be decided in one form. Accordingly, the respondent's purported non-execution or breach cannot undermine the arbitration provision, which exists as a separate and forcible agreement to arbitrate. If the Honorable Tribunal is satisfied with the argument advanced so far, shall the Council move to the second issue?
Yes, please go ahead.
Thank you, Sir Arbitrator. Issue 2 is that SIAC possesses the exclusive authority to manage the dispute with Singapore as the legal seat. It is submitted that the Singapore International Arbitration Center, SIAC, possesses clear and undisputed jurisdiction to entertain and adjudicate the present dispute, as the parties themselves conferred such jurisdiction through Clause 20 of Exhibit P1 and Clause 16 of Exhibit P2, both given in the proposition. Both clauses stipulate that the parties shall seek to resolve any dispute, difference, or controversy, which includes any question of existence, operation, termination, validity, or breach thereof, shall be referred to and finally resolved by arbitration as per the SIAC rules. The arbitration clause given in Clause 20 Exhibit P1 and Clause 16 Exhibit P2 constitutes a clear institutional designation conferring upon SIAC exclusive procedural competence. This was also upheld in Kavner Cremation India Limited versus Bajrang Lal Agarwal, given on page number 23, paragraph 19 of our written submission, affirming that an express recourse to an institutional body binds the parties. This language shall be unequivocal, mandatory, and compulsory. The use of the phrase shall be referred to and finally resolved establishes arbitration as the exclusive dispute resolution mechanism and fulfills this judgment. Moreover, by explicitly naming naming the SIAC as the administering institution, the parties vested jurisdiction to SIAC tribunal and court proceedings. Moreover, in the Hardy Exploration Production India Company versus Government of India, which is also in the compendium, it is a settled principle of international commercial arbitration that party autonomy is paramount, and once parties choose a particular institution and set of rules, they are bound by their choice. It is further submitted that the SIAC rules is set on the principle of competence doctrine. So, upon receiving the claimant's notice of arbitration, which is Exhibit P7, the SIAC registrar himself conducts a prima facie review under the prescribed rules of SIAC, and they themselves found that there is a sufficient basis to constitute an arbitral tribunal. This institutional determination by SIAC themselves is not a mere administrative step, but a recognition that a valid arbitration agreement exists on its face. Once the tribunal is constituted under SIAC's authority, the tribunal process is deemed to have properly initiated, and any jurisdictional challenge must be made to the tribunal itself. By participating in the arbitration, whether by correspondence or filing or through their own objections, the respondents today have also recognized the existence of a dispute arising under the agreement. Having derived benefits from the contract and accepted its amendment through their email, the respondent cannot now selectively repudiate to form a clause embedded in it. The doctrine of approbation and reprobation applies here. By selecting
Can you
SI,
can you
Yeah,
throw some light? Yes, ma'am, please go ahead.
so I was thinking about party autonomy you're talking about. Can you show me some exhibit where you can elucidate the party autonomy from your side or from the other side? Or
hmm.
yeah, please go ahead.
Yes, Madam Arbitrator. So on page number 13 of the Moot proposition, clause 20.2, which is the dispute resolution clause, it itself names SIAC rules shall be applied and the arbitration will be done in SIAC. Later, in Exhibit P2, which is on page number 15, when this is the amendment of agreement co-production. The last line clearly states all other terms and conditions of agreement of co-production dated 10/2/2019 shall continue in full force. So Exhibit P2, if it is amending Exhibit P1, it still says that the arbitration clause from P1 will work. And if we go to arbitration clause P1, since it is signed by both the parties and there is no question in the validity of Exhibit P1, we can say that both the party named SIAC as the institution and rules, and party autonomy here prevails. Does that answer the question, Madam Arbitrator?
Yeah.
Thank you. Sir Arbitrator, you had also had a question?
Yes, can you throw some light on the applicability of the Malaysian laws on this arbitration jurisdiction?
Yes, sir. So the Malaysian law, particularly number 1, it says that if there is any, the IT laws of Malaysia itself says, since we follow the governing law of the contract is Malaysia. If you look into Malaysian laws themselves, the Malaysian IT laws say that if there are two parties, international bodies, and the main source of their communication is through emails or telecommunications, according to their IT Act, not having a signed document also works because since telecommunication is their main source of communication, it binds the parties. So taking that into consideration, we'd say that Malaysian law is also on our side. Plus, we have Malaysian contract law as well, which says in the formation of a contract, there has to be a consideration and there has to be a formal agreement for that consideration. The consideration in this case for the claimant was a 30% shares, and for the respondent it was the no objection certificate. There was agreement because in the email given by the respondents themselves, they say, and I quote, all the terms are accepted by us. So there was acceptance from the respondent's side. Claimants acceptance come when we give the NOC letter to GEM TV. So we can say that if we look into Malaysian Contract Act as well, there is a binding contract between both the parties. Does that answer your question, Sir Arbitrator?
Yes, yes. So I have one more question regarding all these laws which you have just like mentioned, whether these will be applicable or not, the Malaysian laws.
Yes, sir, the Malaysian laws shall be applicable because on page number 13 of the Moot proposition, clause 20.1 of P1 or clause 16.1 of P2, it says that this agreement shall be governed by and constructed in accordance with the laws of Malaysia. So the general law here is Malaysia, but the curial law, which will be taken up by my co-counsel, will be SIAC rules.
Okay, just one last question. Just throw some light on the offer and acceptance as per the Indian Contract Act
Offer
in
and
reference with this case.
Yes, sir. Offer and acceptance in Indian Contract Act starts from the time the offer is made. So unless and until the acceptance is not reached to the person who is giving the offer, there is no valid agreement. In this case, the offer started the moment the claimant gave the respondent saying that this is the agreement, co-production agreement, which was P2. So that was the offer from the claimant's side. Now, acceptance came from the respondent's side when they sent Exhibit P3, saying that so offer from the claimant's side was giving the co-agree Exhibit P2. The acceptance from the respondent's side came in Exhibit P4, where they have said that terms are stated are clearly acceptable to us. This is on page number 17 of the proposition. So the offer is accepted from the claim. Now the acceptance is acceptance. This is the third stage, is done by the claimant when they send the no objection letter to Sky TV. So according to the Indian Contract Act, these all steps were cleared. There was an offer, the acceptance was made by the respondent, and the acceptance of the acceptance was also done by the claimant. And hence, under the Indian Contract Act, this is also a binding agreement. Does that answer your
Okay.
question?
Yes, yes. Give me the provisions regarding the Indian Contract Act on the offer and acceptance.
Offer and acceptance under Indian Contract Act, it is in the acceptance is in section 7, I think, in the Indian Contract Act. It is under IAC Indian 7. Section 7 is the acceptance part of Indian Contract Act.
Offer?
Offer is in I would like to plead ignorance about that concept.
No
I would
issues. Go on.
Coming to issue number 3, issue number 2, issue number 3, but concluding issue 2 beforehand, by selecting the SIAC and its rules, the parties have manifested an unequivocal choice of the SIAC's institution and procedural framework, and a principle which was upheld in Centrade Minerals and Metal Inc. versus Hindustan Copper Limited. Coming to the final and the last issue is that the dispute arising from the co-production agreement are arbitrable under the applicable laws. It is respectfully submitted that the dispute in the present case is entirely commercial and contractual in nature. The disagreement between the claimant and the respondent resolve around the repayment of the initial $2 million at the rate of 5% per annum, and the claimant's entitlement to 30% share of the profits, which we have estimated at $10 million, and accounting of the revenues earned from the film's release. The present dispute, according to the present dispute, the respondents might argue that releasing the film's revenues and accounts will lead to an IP problem. But we have to look at where the problem started. Had we received the 30% shares beforehand, this dispute would not have arisen. Now, trying to change this dispute in an IP dispute, they will try to make it as a dispute of rights in rem. But today, I shall prove that these 2 points will not be applicable. First, such disputes, as today, are personal and confined to the parties, and therefore concern rights in rights in personam and not rights in rem. For this, we heavily rely on Booz Allen and Hamilton Inc. versus SBI Finance Limited, given on page number 27, paragraph 37 of our written submissions. The Supreme Court of India held that disputes arising in rights in personam are arbitrable, whereas involving rights in rem are not. But the case also laid down a threefold test of arbitrability which apply to this case. Number 1, whether the dispute is capable of settlement by arbitration. It is. We ask for $10 million. Whether it is covered by the arbitration agreement. It is, as we see in clause 20 of Exhibit P1 and clause 16 of Exhibit P2. Number 3, whether the parties have referred to it in arbitration. We have. It is written both in P1 and P2. The present dispute satisfied all the 3 conditions given in Booz Allen case and therefore arbitrable. Moreover, if we look into a movie-related case itself, the Eros International Media Limited versus Celimax Links India, given on page number 27, paragraph 39 of the written submission. The courts reaffirmed that disputes involving contractual and licensing rights over intellectual property brings rights in personam are arbitrable, unlike claims concerning ownership of validity or the validity of IP itself, which is not applicable in this case. Honorable Tribunal, the use of comprehensive and inclusive language such as any dispute, difference of controversy is the widest amplitude. It has been judicially recognized to cover every conceivable disagreement that has a direct or indirect connection with the contractual relationship itself. Here are being 3 cases from 3 different jurisdictions from the parties themselves. If we look into the Malaysian case of Padda Gujarat Singh versus Tune Talk, the Indian case of Hindustan Oil Exploration Company versus Hardy Exploration Production, the Honorable Supreme Court of India and the Malaysian court held that when such broad expressions are used, they are to be also interpreted very broadly by the courts as to give full effect of the parties' intention to resolve their disputes through arbitration. Similarly, in the Singapore Court of Appeal, in Tomongluan Holdings Limited versus Silica Investors Limited, it reaffirmed that when an arbitration clause uses expensive terms such as arising out of or in connection with, the courts may presume that the parties intended to include all the disputes that have factual or legal nexus with the contract unless expressly excluded. Therefore, under Singaporean law or Indian law or Malaysian law, the every aspect of today's arbitrability of the dispute arises, the nature of resolution through arbitration. Finally, Honorable Tribunal, the claimant's demands are indisputable. The claimant invested a considerable sum and provided valuable consultancy, fulfilling its primary obligation under the agreement. The respondent's failure to share $2 million and remit 30% profit share, whereas the claimant coming to know about the breach of the contract through social media networking sites constitutes a clear and material breach. I thank the tribunal for its patience and kind attention. I would like to now invite my co-counsel to deliberate upon issue 4 and 5. Thank you.
Just a small query, counsel.
Yes, Madam Arbiter.
So I just wanted to know whether you had sent a consolidated notice for the breach of Exhibit P1 and P2.
Madam Arbitrator, we had sent a legal notice, Exhibit P6, on 10th April 2020, saying it was sent to the Managing Director of Peacock Movies. It is given on page number 19 of the Moot proposition, which says that under instructions from our client, we won the $2 million at 5% interest per annum and 30% share of the net profits. So it included both the $2 million from P1 and the 30% share from P2. So from the claimant side, we did send a consolidated legal notice.
Okay, fine. And the next question is, you had read clause 20 of arbitration clause, right?
Yes, madam.
And I think the arbitration clause is silent about the seat. How do you connect with the SIAC rules, which you mentioned?
Yes, Madam Arbitrator. For this, if we read the arbitration clause itself, if we see the rules, SIAC rules, clause 18 of SIAC rules says that when first we see the rules, that clause 18 itself says that it will become a seat if the venue is mentioned but the seat is not mentioned. So if needed, SIAC can become the seat itself. But the second point that we come to is that participating in this dispute itself, the respondent is binding themselves in arbitration. Moreover, if we look into point 3, is that we have not come here for arbitration without any work from the SIAC themselves. Under SIAC rules, they themselves look into the matter first, then form a tribunal, and then once they realize that this is not merely just an administrative problem but actual contractual dispute, that leads to arbitration. And since we're already on the arbitration phrase, we can say by the competence doctrine that the seat should be SIAC. More about the seat and the venue dispute will be taken up by my co-counsel next. Does that answer your question, Madam Arbitrator?
Thank you. Thank you. Go ahead.
Thank you.
Now the council seeks permission to begin with issue 4 and issue 5.
Yes, please go ahead.
Much obliged, Mr. Arbitrator. Honorable Tribunal, proceeding with issue 4, the claimant submits that the proper seat of arbitration as per SIAC rule must be Singapore because, firstly, the mention of venue in the arbitration clause does not amount to an agreement on the seat of arbitration, as there is no mentioning of the word seat in the clause. And secondly, the Rule 21.1 of SIAC permits the tribunal to determine the seats when the parties have not expressly agreed to one. Honorable Tribunal, in the present case, several factors compellingly point towards Singapore as the appropriate seat. The parties have deliberately chosen SIAC institution which is intricately connected to the Singapore and governed by Singapore International Arbitration Act to administer their arbitration. This institutional link unmistakably reflects their intent to anchor the proceedings within Singapore's neutral and well-established legal framework. And the reference to Malaysia merely accommodates the logistical convenience given that the claimant company is incorporated in Malaysia and certain aspects of the film production occur there. If your Honorable Tribunal, a careful reading of Clause 20 shows that the parties' primary and express choice was to refer their dispute to arbitration administered by the Singapore International Arbitration Center in accordance with the SIAC rules. Also, Honorable Tribunal, in the case of Balco versus Kaiser and Union, the court held that the governing law of the contract is distinct from the curial law, as the seat determines the curial law, not the governing law. And in the present case, the parties have expressly chosen SIAC as the administrative institution and agreed that the arbitration shall be conducted as per the applicable arbitration law of the seat. Also, Honorable Tribunal, in the case of Union of India versus Hardy Exploration, the Indian Supreme Court held that the designation of a venue cannot without more be interpreted as the judicial seat unless the agreement otherwise indicates. And applying the same principle in our present case, the arbitration clause only designates Malaysia as the venue, not the seat. And if our Honorable Tribunal, it is submitted the recognized Singapore as the judicial seat of arbitration, best reflects the party's intention to preserve the neutrality and integrity of the arbitral process and ensures the enforceability of the award within the international legal framework. If Honorable Tribunals are satisfied with the issue 4, the Council now seeks permission to begin with issue 5.
Do you have any
Uh,
authority or precedence to prove your point?
Yes, Madam Arbitrator. As I have quoted a case of Balco versus Kaiser and Union, the Supreme Court of India has established that the governing law of the contract is distinct from the curial law, as the seat, as I mentioned earlier, the seat determines the curial law, not the governing law.
Okay,
Madam
thank you.
Arbitrator, are you with me?
Thank you. Thank you.
Speaker, can you just give me one country in this world who is having friendly laws in aspect to arbitration?
Mr. Arbitrator, can you please repeat your question?
I'm just asking a general question where which country in this world is having laws which are like very, very friendly with the arbitration aspects?
very friendly with the arbitration agreement?
Yes, very good laws.
Okay, Mr. Arbitrator, as Singapore is considered to be one of the best seats in the world for the international arbitration with London, Geneva, as per the report has been cited, because it's a very business-friendly environment it creates for, and usually the seats are always located and there's very good connectivity with the Asia and Pacific region. So Singapore is rarely provided or is chosen by the parties to be the seat for the arbitration, Mr. Arbitrator.
Okay, go ahead.
Much obliged, Mr. Arbitrator. Proceeding with issue 5, the claimant respectfully submits that the unsigned supplementary agreement, Exhibit P2, can be relied upon by the respondent to profit sharing obligations because, firstly, the parties demonstrated a clear intention to create legal relations through their conduct and correspondence. Exhibit P2 is a valid and enforceable modification of the original agreement, co-production agreement, binding the respondent to the agreed profit sharing terms. And secondly, the respondent's conduct amount to the part performance, thereby stopping it from denying the supplementary agreement. The respondent, having reaped the benefits under the understanding created by the supplementary agreement, should be stopped from denying its existence or binding force. The law does not treat signature as the only solid determinant of the contractual validity, where the essential terms of an agreement, as mentioned by my learned counsel, that is, offer, acceptance, consideration, and intention to create legal relations, are otherwise evident. More importantly, Honorable Tribunal, the respondent conducts after the exchange of P2 leaves no doubt that it considered itself to be bound by the supplementary agreement. The respondent acted in direct furtherance of the supplementary agreement by requesting and obtaining a no objection certificate from the claimant to enable them to release the movie. This NOC issued on 7/2/2020, as mentioned in Exhibit P5, was expressly predicted upon the understanding reflected in the supplementary agreement that the claimant would be entitled for the shares of the profit. The respondent, therefore, accepted the benefits arising from Exhibit P2 and released the film and earned revenue in accordance with the understanding. Honorable Tribunal, in the case of Trimax International versus Vedanta Aluminium, the court held that once the essential terms are agreed, absence of a formal signature does not affect its enforceability. The court emphasized that in modern commercial transaction, especially the one with the cross borders, contracts are often concluded through emails, and signature is not the determinant factor of a commercial consent. And in the present case, it is clear from Exhibit P4 of the page 17 of the Moot proposition, as I quote from the respondent's mail, we confirm receipt of your email dated 2011-2019 along with the draft supplementary agreement. The terms as stated are acceptable to us, but due to administrative delay, the signed copy will follow shortly. Also, Honorable Tribunal, in the case of Glencore International versus Sri Ganesh Metals, the court affirmed that an unsigned contract binds a party whose action reflect consent. The court reaffirmed the legal principle that while an arbitration agreement must be in writing, it does not necessarily need to be signed by the parties to become valid. Also, Honorable Tribunal.
Okay, speaker two.
Yes, Mr.
What would be
Arbitrator.
your take? Yeah, what would be your take if the signature is missing and there could be a possible understanding of frauds?
Yes,
How would
Mr.
you
Arbitrator.
substantiate that?
Yes, Mr. Arbitrator, as I have mentioned earlier, the respondent have received the benefits. They have released the movie. They have it's mentioned in the Moot proposition that the movie was a very big hit and they earned a lot. They sell their satellites musical rights without the claimants informing the claimants, and they earned all things. And there is no question of the fraud because the claimant have given them the loan and again has recharged the no objection certificate too, and they have taken all the benefits that is derived from them. So it is very clear from the fact that one party has performed their action but the other party has not. Mr. Arbitrator, are
Okay,
you with-
okay. Very well taken. One more question. Can
Yes,
you
Mr.
tell me
Arbitrator.
how would you substantiate that this P2 is a part of the arbitration agreement and whether it's valid or not?
Yes, Mr. Arbitrator. As P2 says, is Mr. Arbiter, as P2 said in, I will read in the quote from there, that in consideration of such extension and for issuing of no objection letter by the claimant to post-production companies, the respondent agreed to with the share claimant 30% of the net profits derived from the commercial exploitation of the film. So, Mr. Arbitrator, the respondent have not the claimant have given the no objection letter on the consideration that they will get 30% from the net movie, from the total shares from the movie, but the respondent itself that doesn't inform and doesn't fulfill their obligations, and also didn't inform the claimant about selling the musical rights and the satellite rights without informing the claimant, as it's mentioned in the Moot proposition. Mr. Arbitrator, does it clear your query?
Yes.
As the time is up, Honorable Tribunal, may I ask for extension for 2 minutes and conclude the issue 5 and proceed with the prayer?
Please go ahead.
Much obliged. As for concluding the issue 5, as mentioned earlier, in the equity, good faith, and commercial fairness, the respondent must be held bound to honor the profit sharing obligation as stipulated in Exhibit P2, which both the parties intend to govern their dealings, on which the claimant undeniably relies its determinant. As it's mentioned in another one of the case, the English court in Pickard versus Sears held that when one party induces another to act based on certain representation, they can't afterwards deny its truth, if doing so would be very unjust. Now the council would proceed with the prayer. Wherefore, in the light of the facts stated, issue raised, authority cited, and the arguments advanced, it is most humbly submitted before this honorable tribunal that it may please to, firstly, hold that there is a valid and binding agreement exists between the claimant and the respondent as stipulated in clause 20 of exhibit P1 and clause 16 of exhibit P2 when considered alongside the relevant SIAC rules. Secondly, hold that Singapore International Arbitration Center possesses the appropriate and exclusive jurisdiction authority to manage and resolve the current dispute with Singapore as the legal seat of the arbitration. Thirdly, hold that the respondent be directed to fulfill its contractual obligations, which include the payment of the legal amount owed and with the interest determined by this honorable tribunal. Fourthly, award the claimant the cost of these proceedings, which encompass legal fee, administrative expenses, and arbitral cost in accordance with Rule 37 of SIAC. And in addition, pass any other additional order or direction that this honorable tribunal deems fit in furtherance of equity, justice, and good conscience, all of which is respectfully submitted. For this act of kindness, the petitioner shall be duty bound forever to pray. Thank you.
Council, a small query.
Yes,
You were relying
Madam
on
Arbitrator.
SEAC rules. You were relying on SEAC rules. Can you briefly explain me what do you understand by international commercial arbitration?
Yes, Madam Arbitrator. As I have relied on the Singapore International Arbitration Center, as I have said, the venue I have decided that as the venue is based on being the Malaysia, but we have mentioned that the seat should be in Singapore and be governed by the Singaporean law. So, ma'am, international, as we mentioned, as the Singapore International and the International Commercial Arbitration is basically, we can say, is a very dispute resolution mechanism, which can be used when the parties are from cross-border countries or parties are from from different countries and the commercial relationship which span from multiple jurisdiction. And when we talk about SIAC Rule 2016 under Commercial International Arbiter, it refers to the neutral, as it is a neutral party, and the private dispute resolution as is possessed by the Singapore International Arbitration Clause. And madam, and as we conclude the argument, we can say that SIAC 2016, it encourages very speedy and efficiency and neutrality, and its enforceability as is recognized by many countries in many cases in all over the world.
And may I know what type of process you both of you had agreed? Is it a fast track or is it an ordinary way you have agreed?
Ma'am, we have adopted for the fast track arbitration as it is mentioned in the Moot proposition.
Okay. Thank you.
Thank you, Madam Arbitrator.
I think the other side can proceed now.
Greetings, respected members of the tribunal. This is the first counsel. My co-counsel and I shall be representing the interest of the respondent in the case concerning London Business Consultants versus Peacock Movie Production Limited before this honorable tribunal. This counsel shall be dealing with the issue 1 and 2 related to the validity of the arbitration agreement between the parties under Exhibit P1 and P2 and the jurisdiction of this tribunal to adjudicate the present dispute. And the latter will be dealt by my co-counsel. If the respected members of the tribunals are well versed with the facts of the case, may the counsel move on to the submissions?
Yes, proceed.
Much obliged. The first contention put forward by the counsel for the respondent is that a valid and binding arbitration agreement exists between the parties under Exhibit P1 and P2. The Section 2A Clause 1 of IAA, International Arbitration Act, defines an arbitration agreement as an agreement by the parties to submit dispute to arbitration arising out of a defined legal relationship. To be valid, the agreement must be in writing under Section 2A Clause 3, which is satisfied only if the content of the agreement is recorded in any accessible for subsequent reference. Exhibit P2 being unsigned and merely circulated by the email fails to demonstrate unequivocal consent. The respondent alleged no objection letters reference the co-production arrangement generally, but did not expressly adopt or confirm the arbitration clause. Silence or failure to object cannot be considered as consent. In BGM and MRPL GMCT versus Eastern Coalfields Limited, the Indian Supreme Court held that vague or conditional references to arbitration are insufficient to constitute a binding agreement. Exhibit P2 is similarly defective as it lacks the clarity and formality required for a binding arbitration agreement. Similarly, in Carlsberg Breweries versus CSAPL, Singapore Holdings, the court refused to stay proceedings in respect of issues not clearly covered by an arbitration clause. This underscores that arbitration cannot be imposed absent clear consent. Section 2A Clause 5 of the International Arbitration Act provides that an arbitration agreement is in writing if its content is recorded in any form, including electronic communication, so long as it is accessible for subsequent reference. Exhibit P2 fails to satisfy the Section 2A Clause 5. The electronic communication relied upon neither record an arbitration agreement nor demonstrate consents at the end. Exhibit P2 being unsigned and never expressly referring to arbitration cannot be elevated into a binding arbitration agreement merely by virtue of email exchanges. In Con Locus Langster versus Lark International, the US Courts of Appeal held that unsigned purchase orders containing arbitration clauses did not constitute a valid arbitration agreement under the New York Convention. In the present case, Exhibit P2 being unsigned and circulated only by email cannot amount to a binding arbitration agreement. And similarly, the judgment can be seen in the Silverlink Resorts Limited versus MS First Capital Insurance. The High Court refused to stay in favor of arbitration where conflicting clauses created ambiguity, holding that the jurisdiction clause carved out a certain dispute for court determination. Also, coming to the doctrine of party autonomy is deeply enriched in Singapore arbitration law and serves as a foundation principle for the conduct of arbitration proceedings. However, the court have consistently recognized that parties who have not consented to arbitrate cannot be compelled participation in arbitration. It is the according to con- according to the section 3 of the International Arbitration Act, which codifies the doctrine of separability, ensuring arbitration clause is treated as an agreement independent of the underlying contract, in which it is in which uh, this similar statement can be seen in the case Fiona Trust and Holdings Corp versus Privalo, and in that case, it was held that separatability prevents the invalidity of the main contract from inflicting the arbitrational clause. But where the arbitration clause itself is defective, separatability cannot cure the defect. In BCY versus BCEZ, the High Court held that separatability does not breathe life into a clause that never existed. It is submitted that the petitioner's reliance on separatability is misplaced, and the exhibit P2 never contained a clear and binding arbitration clause to begin with. Separatability cannot be invoked to salvage jurisdiction.
Okay,
Coming to
counsel, don't just stick to your memorial. You've heard their arguments, whereby they're saying that you have accepted the proposal, and you have emailed saying that we'll be sending in the signed copy. So include that in your arguments, and then please proceed. What do you have to say about that?
um, the claimant had said that we have accepted the email, but in the exhibit P4 it is clearly stated that the terms as stated are acceptable to us. Due to administrative delay, the signed copy will follow shortly. But in this phrase, the acceptable to us is qualified by a signed copy will follow shortly. That there is a the respondent's acceptance was conditional, which is deferring the binding effect until execution. And the execution, in this case, the respondent made clear that signature was required before obligations would arise, and also while stating,
And you are saying that this move was intentional?
no, indeed not your respected tribunal.
Please proceed.
Yeah, indeed not your respected member of the
Okay,
tribunal.
all right. Taken. Please proceed.
Okay. While coming back to this second issue, which is this SIAC it lacks jurisdiction to adjudicate the present dispute. And while considering the rules of the SIAC, which is the first rule, which is rule number 28 of the SIAC, which states which codifies the principles of competence, which is the which is the principle empowering the tribunal to rule on its own jurisdiction, including objections to the existence, validity, or scope of the arbitration agreement. And while taking the cases such as PT First Media, TBK versus Astro Nusandra International BV, the Court of Appeal clarified that competence is procedural, not substantive. It allows the tribunal to make a preliminary ruling, but it does not expand jurisdiction beyond what the parties have actually consented to. And similarly, in the PUBG Corporation versus Garena International, the court held that the tribunal may only proceed where there is prima facie evidence of an arbitration agreement. In this case, the prima facie, even in this case, the even though the exhibit P1 man can be considered, exhibit P2 is unsigned, and it never expressly adopted by the respondent, and therefore there is no prima facie evidence of consent to arbitrate under exhibit P2. And while coming to the rule 6.1 of the SIAC, which is the rule which permits a claimant to invoke a multiple arbitration agreement by filing either separate notices of arbitration with the consolidation request under rule 8.1. The exhibit P1 contains a valid arbitration clause, but exhibit P2 does not. Since compatibility presupposes the existence of two valid agreements, Rule 6.1 cannot be used to bootstrap jurisdiction over Exhibit P2. To do so it would contradict the principle stated in the case as Astro versus First Media. The court held that procedural devices such as joinder or consolidation cannot override the absence of the consent. And the rule number 5 of the CAC, which allows the expedited procedures, the clause 1 state that the amount in dispute should not exceed 6 million Singapore dollars, and the parties agree. And the clause 2 is parties agree. Clause 3 is exceptional urgency exists. And in Rule 5.2, empowers the president of the SEAC or to determine whether expedited procedure is warranted. And while taking consideration of the case AQZ versus ARA, the Singapore High Court upheld the use of SEAC's expedited procedure because the parties' agreement to arbitrate under the SEAC rules implicitly incorporated the version in force at the time of the commencement, which also included the expedited procedure. Also the court confirmed the also confirmed the expedited arbitration where is valid, where the parties had consented to SEAC rules. And also in cases CCH versus CDB, and also the court granted anti-suit relief, but stressed that such relief presupposes a valid arbitration agreement. The present dispute exceeds the monetary threshold, and also the respondent does not consent, and no exceptional urgencies exist in here. More fundamentally, the Exhibit P2 is not a valid arbitration agreement. And in the case, unlike in the case AQZ versus ARA, where expedited procedure was upheld because the parties had to agree to arbitrate under SEAC rule, here respondent never consented to arbitrate under Exhibit P2. Following the CCH versus CDB and PXH versus BXI case, the expedited procedure presupposes both a valid arbitration agreement and a party withstanding. Both is absent here. And in these cases, it is most respectfully submitted before this honorable tribunal that since the governance, statutory framework, and judicial authority require a clear and unequivocal consent to arbitrate, and as Exhibit P2 fails to satisfy these requirements, doctrine relied upon the claimant cannot operate to confer jurisdiction, and therefore it is submitted that the tribunal lacks competence to assume jurisdiction under Exhibit P2, and any attempt to extend arbitral authority would contravene both the International Arbitration Act and established principles of the CI. If your lordships have no further queries, may the counsel yield the floor to my co-counsel.
Just a small query, counsel.
Hmm.
You were mentioning about the SEAC rules.
Hmm.
Is there anything in the SEAC rules which mandates signature?
In the SEAC rule, there is in the SEAC rule, it was in the SEAC rule, rule number in the SEAC rule, it is that does not contain any rule that makes a party signature mandatory for an arbitration agreement to be valid. And the SEAC rule assumes that if parties have agreed by contract or otherwise to refer the dispute to SEAC, the arbitration will be administered under those rules. And in this case, the SEAC, in this case, in this case, the Exhibit P2 fails this test because the respondent deferred signature as a condition precedent.
Okay, one more query, counsel. You were mentioning that about the fast track process and the value. The claim must be within a particular value. According to you, what is the value here in your particular case?
In this particular case, the value is 2 million US dollars, and according to the SEAC's expedited procedure, it states that the monetary amount should not exceed the amount of the your lordship should not exceed the amount which is the Singapore dollars, which is 6 million. And here it clearly exceeds the amount.
Okay, thank you. Thank you, Counsel.
Okay. Much obliged.
Greetings to the Honorable Bench. May it please this Honorable Tribunal. This is LMC 24 Counsel 2 appearing along with my co-counsel 1 and researcher on behalf of the respondent in the case concerning versus Lantern Business Consultants versus Mason Paycock Movie Productions Limited before this Honorable Arbitral Tribunal. The Council will be dealing with the third, fourth, and fifth issue, which is firstly the arbitrability of the co-production agreement under applicable laws. Secondly, the proper seat of arbitration, whether it is Malaysia or Singapore. Lastly, the binding of profit sharing obligation to the respondent in the basis of unsigned supplementary agreement. With your permission, may the council kindly move on to the first contention?
Yes, you may.
Much obliged, ma'am. The third issue is about the arbitrability of the dispute. The council would like to contend that the disputes are not arbitrable. This is not purely a commercial contract. The co-production agreement involves authorship, creative contribution, moral rights, and copyright ownership of all which are statutory and non-transferable rights in drum under Section 25 of the Malaysian Copyright Act 1987. Rights in drum by nature affect the public and cannot be privately arbitrated. Secondly, the Malaysian law is the proper law under the clause 20.1 under the section 4 clause 1 of the Malaysian Arbitration Act 2005 matters contrary to public policy, including moral rights, fiduciary duties, and dishonest conduct are excluded from arbitration. And also in the case Ajwa for Food Industries was specific interlink, which is dealt in the year 2013. The Malaysian courts confirmed that disputes involving moral or fiduciary obligations are not arbitrable. Moreover, in the Larsen Oil case versus Petroport, in that case also makes clear that institutional rules like SIA cannot override the substantive limit imposed by the governing law. So finally, the damages sought are moral and reputational, such as loss of recognition and injury to honor. These are not commercial claims. In the case Fulfam FC versus Richards, which is dealt in the year 2011, and Amco Asia case, tribunals held that moral or reputational disputes fall outside the arbitral jurisdiction. The arbitration clause here is narrow and designed for commercial payment disputes, not authorship, fraud, or moral rights. Hereby, the council would like to conclude the third contention by saying that this dispute concerns statutory rights, public policy, moral rights, fiduciary obligations, and third-party interests of all which are non-arbitrable under Malaysian law, international practice. Therefore, the arbitral tribunal lacks jurisdiction. And also here, with the permission, the council is moving on to the fourth contention.
Counsel, you are mentioning that it affects the third-party rights. How is it? Can you briefly explain that?
Indeed, madam, because about the distributors here, the GEM TV, and also about the broadcasters and the satellite group, everyone is included in that, and it is also mentioned in the proposition itself. So it will affect the third party, which is we cannot make it the dispute. Therefore, it's not arbitrable.
So you feel that is not right in persona?
Indeed, no, your lot. Indeed, no, your man. I apologized.
Okay, carry on. Thank you.
Much obliged, madam. So the fourth issue is about the seat. So here the council would like to contend that the most respectfully submitted the both exhibit P1 and P2 expressively identify Malaysia as the venue, and the contract also chooses Malaysian law are the governing law. When the venue and governing law coincide, courts consistently treat venue as the legal seat. This principle is affirmed in BGS SGS Zone JV versus NHPC, and also in the case Hardy Exploration versus and Production versus Government of India, where the courts held that party autonomy prevails and the venue makes it in the seat unless stated otherwise. And also the SIAC Rule 21 applies when the agreement is silent, which is not the case here. Therefore, Malaysia remains the legal seat. And also the SIAC administration does not change the seat. The claimant wrongly realizes that the SIAC's administrative activities to imply Singapore as the seat. However, the institutional rules regulate procedure, not the determination of the seat. The Supreme Court in the case Barco versus Kaiser Aluminium held that administrative convenience cannot override the parties' contractual choice. Old SIAC actions in Singapore were purely procedural. They cannot displace militia, which the parties expressly designated. Applying the Singapore law would also conflict with the agreed Malaysian governing law. And also, the tribunal constitution cannot shift the seat. The claimant argues that because of the tribunal was constituted in Singapore, the Singapore becomes the implied seat. This is legally unsustainable. As clarified in the case Lesotho Highlands versus Swissbro, the procedural or logistical acts have no relevance in determining the seat. Only the contract determines the jurisdictional seat. And in this case, the agreement unambiguously points to Malaysia. And the next point is that governing law, which is the Malaysian law, also governs the arbitration clause. The agreement expressively chooses Malaysian law as the governing law for the entire contract. This governs not only the substantial right but also the arbitration clause itself. SIAC rules cannot override this choice. Recognize Singapore as the seat would contradict the chosen venue, the chosen governing law, and the clear intention of both the parties. Therefore, the arbitration must proceed under the Malaysian Arbitration Act, not Singapore law. See here, the Council would like to conclude the fourth contention by stating that, in the light of the expressed contractual terms, established judicial precedents, and the principles of party autonomy, it is respectfully submitted that Malaysia, not Singapore, is the proper seat of arbitration.
Council, a small query.
Madam.
Is there any exception when it is a fast track process? Do you feel that there will be any exception to these rules which you mentioned right now when it is a fast track process?
Madam, the Council seeks a few further reference.
Okay, no worries. Carry on.
Much obliged, Madam.
You can go ahead with your arguments.
Madam, the Council will come into that after the after dealing the contention 5.
Okay,
Will answer
fine.
it.
Fine.
Much obliged, madam. So the last contention is about the unsigned supplementary agreement. So here the Council would like to contend that the email acknowledgement is not acceptance. Most respectfully submitted that the respondent's email acknowledgement in Exhibit P4 does not amount to acceptance of Exhibit P2. So the phrase acceptable in principle shows conditional consent, not a concluded agreement, as held in Feldhaus versus Blindly and also in the case Trimits International versus Vedanta Aluminium. So neither silence nor conditional statements can constitute acceptance, especially where parties contemplated a formal signature. Under Section 10 of Malaysian Contracts Act 1950, a valid contract requires clear offer, acceptance, and intention. Since the Exhibit P2 remained unsigned, there was no meeting of minds. Authorities like Broaden versus Metropolitan Railway case and also Kada Company versus Raymond and Company case further confirms that incomplete or unsigned draft cannot create enforceable obligations. This Exhibit P2 never became a concluded contract. And also the claimant's reliance cannot create binding obligations. The climate issuance of no objection letters Exhibit P5 series was a unilateral act, not a production of mutual agreement. The respondent never signed P2 and conditional consent in Exhibit P4 cannot substitute formal acceptance. In Feldhaus case and also in the Trimix case, courts held that the reliance cannot override the absence of concluded contract, especially where the parties intended a signed document. Since P2 remained unsigned and the claimant acted voluntarily without inducement, no contractual obligations can rise from the reliance. And also, the estoppel cannot validate an unsigned agreement. It is further submitted that the estoppel cannot be used to create a contract where none exist. Exhibit P2 remained unsigned and the respondent's email clearly stated that the execution was pending. As held in the Haichi case, estoppel cannot replace statutory requirements or create consent where none was expressed. The claimant's reliance was unilateral and unsupported by any definite promise from the respondent. Therefore, the estoppel convert Exhibit P2 into a binding agreement. And also, the Council would like to say that the supplementary agreement Exhibit P2 was intended to be a return and a signed amendment. The claimant themselves requested return of a signed copy, which is in Exhibit P3. Kindly acknowledge and return a signed copy for your records. This established that signature was required for the acceptance to be complete. Without signature, there is no enforceable agreements, acceptance, only negotiations. The Council seeks the attention of your madam to this also. And here the Council can conclude the Contention 5 by that, since Exhibit P2 was never signed, acceptance was conditional, reliance was unilateral, and estoppel cannot cure the absence of mutual consent. Exhibit P2 is unenforceable against the respondent. Madam Arbitrator, the counsel is coming back to the question. With your permission, may I answer? Much
Yeah, yeah.
obliged, madam. SIAC Rule 5 allows fast track only when both parties consent, or the second point is that the claim value is under the USD 6 million, or the third point is the exceptional urgency exists. None of these conditions are satisfied here. So therefore, the fast track procedure cannot apply here. The fast track is an exception, not the norm. In this case, none of the statutory conditions for that exception are satisfied. If your Madam Arbitrator have no further queries, may the counsel move to the prayer?
Okay, fine. That was not my question. I was asking you about the silence about the seat. I was asking you about that. It's okay. You have given an answer. No worries. You can just search on that, right?
Much
When
obliged,
it is a
ma'am.
fast track process and arbitration clause is silent about the seat, is there anything which you can clarify on your side? No, that I was asking, but no worries. You can answer later. No worries.
Much obliged, madam. So the counsel is moving on to the prayer. Wherefore, in the light of issues raised, arguments advanced, and facts adduced, the authority cited, it is most humbly and respectfully prayed that this honorable tribunal may be pleased to adjudge and declare that, firstly, the Exhibit P2 does not constitute a valid and a binding arbitration agreement under Section 2A of the International Arbitration Act. Secondly, the SIAC lacks jurisdiction to adjudicate the present dispute, and the respondent's objection must be upheld. And thirdly, the dispute arising out of the co-production agreement are non-arbitrable under applicable laws. Fourthly, the Malaysia, as stipulated in the venue clause, is the proper seat of arbitration, not Singapore. And lastly, the unsigned supplementary agreement, which is the Exhibit P2, cannot be relied upon to bind the respondent to any profit-sharing obligation. Pass any other order, direction, or relief that this honorable court may deem within the interest of justice, equity, and good conscience. For this act of kindness, the counsels for the respondent shall duly bind forever pray. Much obliged.
Counsel, one last query.
Madam?
I just want to know whether you have any precedents or authorities to show that you can wriggle out of your obligations on technical grounds. That was the fifth point which you highlighted. No? Is there any precedents or any authorities you can show?
Indeed, ma'am.
By then, others move on to rebuttals and sub-rebuttals.
Much obliged, madam. So as held in the Feldhaus versus Blindly and the Trinix International versus Vedanta Aluminium, they and apologize, madam. So under Section 10 of the Malaysian Contract Act 1950, a valid contract requires clear offer, acceptance, and intention. Since Exhibit P2 is remained unsigned, there is no meeting of minds. So it is also mentioned in the cases like Broaden versus Metropolitan Railway and Kurda Company versus Raymond and Company further confirm that incomplete and unsigned draft cannot create enforceable obligations. This Exhibit P2 never became a concluded contract.
Okay, fine. You rely on Malaysian laws. Okay, fine.
Much obliged, ma'am.
With the permission of the Honorable Tribunal, may I move for rebuttals?
Yeah, move on.
Thank you, Madam Arbitrator. May it please the Tribunal, the claimant will now present a structured rebuttal answering the respondent's submission and address key objections in a clear issue-wise format. Number one, the respondent's entire argument is based on the fact that the respondent did not consent to arbitration of Exhibit P2. But what the counsel wants the tribunal to understand is the counsel feels is that the arbitration clause is not given in P2. It is in Exhibit P1. And P2 merely transfers the arbitration clause from P1 to P2. So saying that they did not agree to arbitration is false here because P1 was signed by both the parties. And when P2 says we follow the terms and conditions of P1, automatically the signing of P1 comes here where both the parties signed and said that arbitration shall follow. Another thing that was raised by the respondents themselves, as raised by Madam Arbitrator, is that they wrote in the email verbatim that they accept the terms and but still did not share the signed paper. This clearly shows how they hide behind technicalities while they take the consideration, which is the no objection clause, and reap the benefits of the claimant's trust and without fulfilling the agreement. Number 3 is coming to page number P3, page number 16 of the Moot proposition. The requirement of a signed document is purely for archival and record basis. It is written in verbatim by the claimant in their email, which says that first, the respondent says that all the terms are acceptable by us, and in P3, the claimant themselves says, kindly acknowledge and return a signed copy for our records. This shows that for the claimant, it is not about consent, but it is purely for administrative purposes and archival records. Then coming to the next point, Honorable Arbitrator, is that their contention is fundamentally flawed. The respondent repeatedly admits that the P1 contains arbitration clause, yet they did not consent to it. Their entire contention lies that P1, they did not consent to P1. However, according to the proposition, P1 has a valid arbitration clause. Coming to the seat dispute, with respect to the SIAC rules themselves, if we look to the initial P1 agreement, if we look into Rule 18.1, the rules expressly state that if the seat is unclear, Singapore becomes the default legal seat. And if in our case, we look at a fast-track case, fast-tracked arbitration processes can still apply according to Rule 5 of SIAC. Moreover, exception in this, it was wrongly pointed out by the respondent, this dispute is over 10 million US dollars and not just 6 million US dollars. So the fast track exception does apply here. Second point that the respondent put out is that the requirement of a signature is not a condition precedent, because the validity of an arbitration clause here does not depend on a formal signature, but on the clear intention of the parties. There was a promise, there was consideration. They took the NOC, they took the money, they refused to give us the money and reaped all the benefits. Here, they took all the benefits, but left the claimants to themselves. Here, they had raised the 8th point, which is there was no consensus at EDA. This is completely shattered when we look into their Exhibit P4, where they in verbatim say the terms are as stated are acceptable to us. Due to administrative delay, the signed copy will follow shortly. They do not say that they did not send the signed copy because there were some issues with the terms or because they were not agreed to the terms. They said it was an administrative delay. We're sending it soon, but we agree. So you cannot go back and say that there is no consensus at EDA. Let's say there was a consensus at EDA. How can you take the NOC, take the money, reap the benefits, and then say there was no meeting of the minds? Coming to the last point is that they try to make this misappropriate this issue as an IP issue. It is not, Madam Arbitrator. In the Vidya Dolia case of 2021, it was submitted that commercial disputes, even involving those of IP, are arbitrable when they are rights in a persona. Nothing here affects a third-party right. All we ask is for 3 things. Number 1, that as a mischaracterization, but it is solely a contractual obligation. With this, the council ends their rebuttal. Thank you.
Counterpart, you can submit.
Much obliged, madam. So when coming on the first issue, the respondents would like to celebrate and the consent deferred is consent denied. The exhibit P2 expressly awaited signature. Signed copy will follow shortly. Execution was a condition precedent. So the precedent in the case recurs Welmatam versus the IOC, which is in India. So it states that the unsigned drafts cannot bind absent unconditional consent. And when it comes to the second issue, so the SIAC's role is administratively supervisory jurisdiction clause from the seat. The clause 20 of Exhibit P1 designates Malaysia as venue and governing law. It states Malaysia is the jurisdictional seat. And when it comes to the third issue about the arbitrability, the profit sharing obligation implicate third party rights because of the broadcasters, distributors, regulators. These are right in rem, not right in personam. And when it comes to the fourth issue, it is about the seat of arbitration. And now we have to contend that venue plus governing law is equal to the seat, and the clause 20 expressly designates Malaysia as the venue and the governing law. And in the precedent, BGS SGS Soma JB versus NHPC, and also in the case Shashogo versus Sharma, the venue designation with governing law points to a seat. And from the last issue about the unsigned supplementary agreement, the conduct cannot substitute for signature where execution was a condition precedent. And the estoppel cannot create consent where none exists. And also the Section 7 of Indian Contract Act, Section 7 of Malaysian Contract Act also states that the acceptance must be absolute. So by this, the council conclude, Madam.
Sonama?
Yeah, so time for our feedback. All right. I mean, yeah, okay. So I would say both the teams have done really well, though I received your memorials at the last moment. But I was amazed to see the research work you all have done. And so very great, whether it is SIAC rules, the Malaysian laws, or you talk about principles like consensus addendum, and also coming to the technicality of signing of contract or the compendiums and offer and acceptance. So all these topics have been taken very well by all of you, and you all answered also very well promptly, referring to your memorials. It was great. All the best. Let's see which is the best team which wins. Great. Thank you from my side. Seema ma'am, please.
Thank you, Sonama. At the very outset, heartiest congratulations to all of you for participating in such event and gaining as much as you can. These are the part of learning, irrespective of the fact that whether you win or lose. And the best part is that you all are in the final rounds. So what I want is that just to see a smile on your all face. Be relaxed. You can pat yourself because you have reached this far. No? So let's have a smile, okay, and be relaxed, irrespective of the fact that who wins or who loses, because these are just part of learning which you are having. These experience will help you to build good skills in your future. Whatever profession you take in future, that's litigation, arbitration, mediation, whatever you take, these all are going to add beauty to that, right? And I was amazed by the way you were, like the homework which you had done and how productive it was in the competition. Keep doing that. On a constructive note, only on one aspect regarding clarity of thoughts and expression, right? Because since it is a competition, I believe that this is a vital part. Once when you are in a competition, this plays a vital part there, clarity of thoughts and expression. So this is just for your future sessions, that in your future sessions, you can just take care of the way how you bring your thoughts, because you are arguing something, you're trying to put your points here. So that must be, the thoughts must be very clear to the person who hears, also to your counterpart. So in your future sessions, just try to put it in a beautiful manner. It's not that this time you have not put, but just add on to that in your future sessions by putting up the facts at the first instance, how you are connecting with the facts in your hand, and what is the point which you are going to prove to us or to the counterpart. And if there is any law connected to it, which is that law? Be specific. Don't run. You can be very specific about the law. And thereafter, if there is any precedents or any authorities which you can show, so that it adds beauty to your point. In such manner, if you submit, it will add beauty to the way you are submitting, and also it will be pleasing to the persons who are hearing, and also it will go into the mind of the counter side also. That is about the clarity of thoughts. With respect to expressions, especially when you are having rebuttals and sub-rebuttals, be mindful about the opposite counsel. It is not that we are trying to hurt the other person. Just be mindful the way you are submitting it, the tone, the manner, so that the other party also feels that you are just trying to put your points, or you're just trying to highlight your points. not you are going to attack the other person. These are simple things which you can carry on for your future sessions. Otherwise, I enjoyed the sessions. Best wishes to all of you from my side. Thank you.
Thank you, ma'am.
Thank you, ma'am.
Yes, my dear students, it was really great to be with you people, and everybody did a fantastic job. My only takeaway is that regarding the provisions of the law, you should be like aware of a particular provision if you're dealing with it, having basic knowledge regarding the particular provisions, be it contract act, be it substantive law, be it a procedural law. So that's where, we need to know the provisions also, because the knowledge of BEREC also becomes very important and basic. And apart from that, everybody did a great job. Wishing you all the best for your future.
Thank you, sir.
Should we log out? I mean, there's no.
Okay. Thank you, participants. Thank you so much. I hope I am audible to everyone. Thank you, Seema ma'am. Thank you, Sona ma'am, and thank you, Hamad sir. The participants may leave the meeting. The judges can stay here and finalize the score sheet.
Thank you.
Sona madam, I think we have to discuss and then we have to put the marks.
Yeah. Yes, ma'am.
Okay. So I don't find sir. Sir is there, no, with us? Mohammed sir? Okay, fine.
Yes, ma'am.
Okay, fine.